afternoon, my lords. Just on Lord Justice Green's point about EU law, would it be acceptable if we just agree the position over? I'm sure we can agree.
More than acceptable.
Thank you. I think that might be more helpful. I was going to take you to the Commission's guidelines on vertical restraints. They're at Authorities Bundle Volume 5, tab 34. And can we take it from page 2068, please, of the bundle?
Bundle 5, tab 34.
Exactly. 2068. And here you see the heading Application of the Block Exemption Regulation. I just draw your attention to the opening words of Recital 23. So for most vertical restraints, competition concerns can only arise if there's insufficient competition at one or more levels of trade. That is, if there's some degree of market power at the level of the supplier or the buyer or both levels. And we've seen that now a number of times. And then could we go on, please, to page 2072? And you can see at the bottom of the page the heading, Hardcore Restrictions, under the block exemption. And if we turn the page, at recital 48, we see the guidelines in relation to Article 4A, which was the pricing hardcore restriction. And if we look at that, that says that the hardcore restriction concerns resale price maintenance, RPM. And so you did put to me that those words...
I'm so sorry, 48 or 40?
Recital 48, so it's page 2073 on the left-hand side.
203.
Do you have that?
Yeah.
So it's the guidelines, so these are guidelines, so they're interpretive guidelines. They say that 4A, Article 4A concerns resale price maintenance. That is, agreements or concerted practices having as their direct or indirect object the establishment of a fixed or minimum resale price or a fixed or minimum price level to be observed by the buyer. And just pausing there and coming back to the discussion before the lunchtime adjournment, the distinction that we draw is between, on the one hand, an agreement which has as its object the establishment of a fixed or minimum retail price, which is what is described here, and on the other hand, an agreement which has as its object something which may well result in the lessening of price competition, or even an agreement which has as its object the lessening of price competition. So it's not enough that price competition will be reduced, even that the agreement has the object applying the proper test of reducing price competition. It's that it's got to have the object of establishing a fixed or minimum resale price. And that's really the key distinction on which we rely. And then if you look down this paragraph, you can see, so that defines RPM, just pausing there, because you can see there RPM, that is, and so RPM is defined. And then later on it says, however, RPM can also be achieved through indirect means. So we don't quibble with that at all, but those indirect means can include fixing the maximum level of discount the distributor can grant from a prescribed price level, making the grant of rebates conditional on the observance of a given price. But those are all indirect means of achieving the thing at the beginning of the paragraph, which is the establishment of a fixed or minimum price. And really, if the court goes down and looks at all of the things in this paragraph, none of them are in this agreement in the present case. So nowhere here does it preclude terms which might have the effect or even the object of raising prices or reducing price competition. That is not what it's about. And this really is a sort of black letter point, we would say. Now, then if we go to, we then see at paragraph 50, the hardcore restriction set out in Article 4B. Now, that isn't one of the ones relied on by the CAT, but I just refer to it because I just take you to see what paragraph recital 52 says on 2074. That says that the internet is a powerful tool to reach a greater number of customers and variety of customers than by more traditional sales methods, which explains why certain restrictions on the use of the internet are dealt with as resale restrictions, in principle, every distributor must be allowed to use the internet to sell products. And we say, well, retailers are, in DECA's selective distribution system, allowed to use the internet to sell products. And then at paragraph 52, you can see that, in the same paragraph, that it is, paragraph 54, over the page, at the bottom of page 2075, that under the block exemption, the supplier may require quality standards for the use of the internet site. So you can place conditions on what the internet site should look like. And then we have at paragraph 56, the hardcore restriction set out in Article 4C, which is the other restriction relied on by the tribunal. And this excludes the restriction of active or passive sales to end users. And if you look, looking at in the same paragraph, within a selective distribution system, the dealers should be free to sell, both actively and passively, to all end users, also with the help of the internet. And so, again, retailers need to be able to use the internet to sell.
Wait. Sorry, you're going now so fast. I'm failing to catch up with you in 56.
56 concerns, my lord, the hardcore restriction.
Yeah,
second
After
of
the
the
word 51.
Yep. Can you just unpack the without prejudice to the possibility of prohibiting and the last bit of that first sentence?
Are you on 56, my lord?
Yes, I am.
So
it says the hardcore restriction excludes
the restriction of active or passive sales. So passive sales are, for example, internet sales, where consumers come to you. And by
hardcore restriction excludes the restriction.
But without,
so does that mean it prevents them or it doesn't prohibit them? Hang on, the hardcore restriction.
Oh, it's badly worded. So
yeah,
it means that it prohibits the restriction.
That's what right, okay.
So it prohibits the restriction of active or passive sales without prejudice, so there's a proviso, to the possibility of prohibiting a member of the network from operating out of an unauthorised place of establishment.
Now I've unpicked the syntax. It's possible to prohibit a member of the network from operating out of an unauthorised place of establishment.
Exactly.
Right.
Exactly. And that's important, obviously, for
like
the
a market
case.
store.
Sorry to be slow.
Like a market store.
Yes, or like an internet site that doesn't have your name.
Yeah.
So, and then you see further down a reference to, within a selective distribution system, the dealers should be free to sell, both actively and passively, to all end users, also with the help of the internet. So any obligation which dissuades dealers from using the internet is a hardcore restriction. But we say, and I'm going to show you the Coty case in a moment, that this is not what happened here. Clause 15 with the, read together with the email, does not restrict any of the retailers from using the internet. They are free to use the internet, and they do. Now,
but it also says you don't have to have the same criteria, identical criteria for online and offline sales.
No, exactly, because they're different channels, and so you can lay down qualitative criteria, and that is not a hardcore restriction. Before I turn away from this document, can I just show you on page 2084? Just draw your attention to recital 106, so the positive effects of vertical restraints, and again the reiteration of the positive effects by promoting non-price competition and improved quality of services. When a company has no market power, it can only try to increase its profits by optimising its manufacturing or distribution processes. In a number of situations, vertical restraints may be helpful in this respect. So again, it's reiterating the same point. That's why market power is important. And then if we go on to 2097, please, can I just ask you to read to yourselves? This is under the heading Selective Distribution. You see this at the top of the page. And can I just ask you to read to yourselves recital 177? it's similar to what the CMA, I took you to what the CMA said in its guidance. This is very similar to that. And then just a point, I want to make a point about how the vertical block exemption, how block exemptions are supposed to function. And can I do that, please, by reference to how the CMA views block exemptions? And that's the next tab in the bundle. So this is the CMA's recommendation. And if you turn to page 2115, so this recommendation followed the expiry of the EU block exemption following Brexit. And there was then a period of evidence gathering as to whether or not the UK should put in place a similar block exemption for UK law, or whether there should be no block exemption in place. And you can see that the recommendation is that it is appropriate, we see this from 3.1, to replace the retained EU instrument when it expires with a UK order. And we see from 3.2 that the CMA's recommendation is based on evidence that it gathered. And we see what the CMA says about that a vertical block exemption provides legal certainty for common types of commercial agreements that pose no significant harm to competition. I'm reading from 3.2. Also has the merit of relieving competition authorities and the courts of the burden of reviewing such essentially harmless agreements. And so it's beneficial to have a safe harbour for categories of vertical agreements that are considered likely to satisfy the requirements for exemption. And you see at 3.3, and this is an important point, the legal certainty for business. And it operates as a black letter piece of law which allows businesses to look at their agreements and decide whether they're in or out. And so it provides very important business certainty that allows businesses to put in place beneficial commercial relations without provisions, without worrying about how competition law applies and what the market says and what the economic analysis is and what's the purpose of this clause. They don't need to worry about all of that. They just look at what the agreement says and they ask themselves, are we within it or outside it? And then you see at 3.4 an elaboration of the point that it helps authorities and courts to avoid spending time scrutinising vertical agreements between businesses with relatively low market shares in circumstances where there's unlikely to be any significant competition concerns. And so I draw your attention to that because it's an important point to have in mind when considering the application of the vertical block exemption. It should be something which is easy to do on its face. And I'm going to turn now to my submissions, and I've made many of these.
Just before we go on,
yes,
in relation to the Commission's vertical restraints guidance and the guidelines on the block exemption, you made the point by reference to the guidelines.
Yes.
That they're concerned with fixing prices. How does that fit in with the different language in Article 4A of the block exemption, which doesn't refer to fixing? It refers more broadly to the buyer's ability to determine its sale price. They're not quite two sides of the same coin.
Well, sorry, let me just find the language of the block exemption itself. So you're right that the language is slightly different, but we say that, so...
When you complain aid, you can assume that, of course, the Commission's guidelines are relevant and admissible, but they don't bind the court.
No, that's a fair point, but, my lord, we say that there is no material distinction between the guidelines and the provision of the regulation itself, because it's talking there about the restriction of the buyer's ability to determine its sales price. And so, again, the distinction is between an agreement or clauses which have the object of restricting the retailer's actual freedom, its discretion to sell at any price it wants to, on the one hand, and on the other hand, falling outside the clause, falling outside the provision, a clause which has the object of merely reducing price competition or making it more likely that retailers will price higher. That's just not what's captured by this provision. And as I said,
so just recital
yes.
48 of the vertical restraints prohibits the establishment of a fixed or minimum resale price.
Yes, which is the other side of the coin, we say, of restricting the ability of the retailer
I get
to set
that.
its own price.
I'm not certain if they're exactly coextensive.
Well,
I mean, they're similar, but one is about having in your own mind a fixed price and saying, I'm not going to allow you to go below it, which I don't think it's not on the evidence what happened here in relation to Deckers. Whereas the other is more broad and it is about restricting the ability to determine its sales price. So that's Up and Running's own ability to set its sale price, irrespective of whether it was complying with something which was imposed upon it by Deckers.
but my lord, the critical word is ability.
Yeah.
And so it's not the incentives, it's not something which affects the incentives or the likelihood of Up and Running pricing lower. That's not what this is about. It's something which restricts the ability of it to do so. And here, the finding of the tribunal was that there was nothing to restrict. I'm going to show you the findings in a minute. So maybe we can resume this debate.
Terminating.
So
Terminating.
no, because
restricts
they
its
could
ability.
sell their products.
We get all that, absolutely.
Whatever price they wanted on the main channel.
Absolutely. All of that's understood. But nonetheless, on the facts, they wanted to discount to a level, or they were perceived as wanting to discount to a level that Deckers didn't like, and therefore, on the facts as found, rightly or wrongly, they terminated.
And my lord, but we say critically that that's not restricting their ability. Let me show you. Can I do it by reference to the judgment?
Yeah.
So
I mean, we understand the point you're making. My point is really a question of interpretation of 4A in the light of the guidelines. I mean, one, I accept it's a guide to interpretation. It wouldn't bind the European Court or anyone like that. Wouldn't bind us, but it's valuable, it's admissible, and so on and so forth. Insofar as things from the Commission are admissible.
it's admissible. It's often cited. It's not binding on you. I agree. It's persuasive. It's a persuasive weight, but I do place emphasis on it because if one is asking yourself the question, well, does Article 4A in the regulation, does it apply to any measure which might have the object of lessening price competition? If that's the question, then I say no. And an important reason why we say no is the guidelines, because that explains how the Commission expects these to operate. Can we go to the judgment so I can quickly make my submissions on the vertical?
Sorry, just to pick up that last point there, I'm just trying to follow it. I mean, you say that 4A would apply if there was a provision that said you shall not set the sale price below 100.
Yes.
Let's assume the thing just says you can set any sale price you like, but if you set it less than 100, this agreement will terminate.
Also RPM.
Right.
But we're not in that. We're not there because they.
But you weren't making a very techie point, if I can put it that way.
I'm not. I accept that indirect means of achieving the same end are captured. But my point is that they can.
Or more broadly, we whiff in the air. You're going to slash prices. We're not going to stand for it. Ergo, we terminate. So no idea what the price might be, but we just think you're going to go too far. We don't trust you. Here's the letter of termination.
Well, if that's shown to be, yes, I mean if that's what
that's
the
the
agreement
worst. That's
says,
one interpretation of the facts.
But one is looking. The one important thing to bear in mind here, of course, is that one is looking at the terms of an agreement. Yes, you can construe the agreement by. I mean, you're looking. That's why I took you to the CMA guidance. You're not looking at how a clause was enforced in a particular.
Well, in this case, this is one of those AEG. It's an action in the context of a selective distribution network. So it wasn't a consensual action, but it's more in the lines of a concerted practice, isn't it, than anything else.
So okay, let me take.
Otherwise, unilateral act is nonetheless caught because.
So let's assume that there's a concerted practice, because I would say that one needs, because of the legal certainty provisions, imperatives, one needs to be looking at the clauses of the agreement, what was actually agreed, and is this prohibited? And we say no. But let's take the other side's case at its highest, that there is a concerted practice, or say there is a case where there is a concerted practice whereby the retailer says we're going to price below 100, and the supplier says, right, we're terminating, and that's a concerted practice. I would agree that that is a hardcore restriction. And the key distinction between that and the present case is that here, Up and Running was free to price however it wanted on its site. And that's really the key distinction. And let me show you, I'm going to take you to the judgment, back to the judgment. And we've looked at some of these paragraphs, but let me just make crystal clear what we're saying. If we go to, so we're in Core Bundle 1, tab 10, and take it from page let's take it from page 197. Let me just show you one point as we go along. So here they say that the tribunal finds at para 139 that the control was designed for a broader purpose, so as to allow deckers to restrict on a case-by-case basis the use by retailers of alternative sales channels which were not consistent with the selective distribution system. And I say this by way of context because, of course, the vertical block exemption is not concerned with ascertaining the purpose of a particular clause. I mean, it's meant to be just a black letter piece of legislation. You look at the clauses, you look at what's agreed, and you decide whether they're in or out. That's its function. And so it's no part of the analysis under the block exemption to ask about what the purpose of something is. But anyway, leaving that aside, if we go on to page 200, then we see the heading above para 140, the relationship between the enforcement of the contractual provision and the ability of Up and Running to set prices. And you can see here, if we look at the first part of para 141, compliance with the agreement meant selling Hocker products only through the Up and Running branded channels. Now, so far, so good. That's unobjectionable. You've seen under Metro that an important part of a selective distribution system is the ability to constrain retailers from selling only within the channel. And then you see deckers must be taken to have known that this would reduce the extent to which Up and Running was able to discount Hocker product. Now, again, pausing there before we get to the reasons why the tribunal found that. Again, almost any supplier that sets up a selective distribution system can be taken to know that preventing retailers from operating outside that system is likely to reduce price competition. And that's just something which is inherent in selective distribution systems. Then we go over the page and look at the reasons. So the key reason, looking at these three reasons, so we have at 1, it was clear that the Running Shoes website would operate as a clearance website, necessarily implying greater discounts. 2, deckers knew that Up and Running was not comfortable discounting significantly on the Up and Running website. That was the whole point of the new website. So that's the tribunal's key point. But our submission is that whether Up and Running was comfortable discounting on its main channel was nothing to the point. The point that the tribunal needed to focus on was what the agreement provided in relation to Up and Running's freedom to price, its ability to price, its freedom to price. And there was nothing in the agreement that fettered Up and Running's decision-making in relation to pricing at all. The only factor is that Up and Running had its own commercial incentives not to discount heavily on the main channel, but that's almost always true of selective distribution systems. And so then you see at 143 the point that we've already noted, that Decker's witnesses made a point of telling us.
About the parenthesis in 142, I'm just looking at that again. What are they finding there?
Well, they're finding that Decker's and one other retailer in the clearance channel were discounting heavily in relation to discount products. I mean, I just don't see why that's an objectionable thing.
I'm not certain if they're saying it was objectionable or not here.
I don't know.
So they wanted to prevent up and running entering the clearance channel, pricing Hocker at the low levels it wished to,
Yes.
in the same way Decker and other retailers were doing at the time, i.e. sell at the price they wished to.
But of course...
Not certain what that means.
No, I don't know how that fits into the analysis. But the key point here is that there was no restriction imposed on Up and Running's ability to price as it wanted.
Well, there's no restriction on Up and Running's ability to price as it wanted, either in its stores or on its branded website.
Well, that's the key point, my lord. Right. So there's no, and that's the key point. So there's no, it's well, not...
Yes and no. We absolutely get all the limitations. Yeah. We understand the ins and outs of the findings of fact. I think what they're getting at is that Up and Running felt that if it discounted on its branded website or through bricks and mortar, it couldn't do so to the extent it wished, because it would undermine its pricing and its quality, etc., etc.
Yes.
And therefore it wanted to go a bit further, so it did it on an anonymised website. So it wanted to push prices even further down, even though it could do that.
Yes.
But economically it wouldn't want to. Now, that may raise quite a discrete legal issue as to whether that's a restriction or not, because you can do so on your branded website, but economically you wouldn't want to.
My lord, it does raise.
Therefore, you do it, as it were, sub silentio on the anonymised one.
Well, my lord, it does raise a discrete legal issue that wasn't grappled with by the tribunal, and it's a discrete legal issue which should be answered in the way that I've suggested, which is that there is no constraint on Up and Running's ability to price these products, to sell these products at any price it wants to, in its store and on its main website. And what we see from time and time again, both in the block exemption and in the case law, and we see this in the opening words to Article 4C of the regulation, is that you are allowed as a supplier that sets up a selective distribution system to stop retailers selling from unauthorised places or through unauthorised channels. And it's obvious why that is. It's to prevent free riding. But of course, that is almost bound to result in the suppression of price competition for that.
Is it AEG that said that some level of price competition is inherent, or price muting, or something? I think it was AEG.
Well,
possibly even Metro back in the 70s.
Yes, Metro certainly says that some level of softening of price competition is inevitable in a selective distribution system, and you see it. We saw that in the Ping Court of Appeal judgment reiterated. And you see it in the various guidelines and the recitals to the block exemption that I took you to. They all say that. That's only problematic if there isn't sufficient inter-brand competition. And so going back to the judgment...
Just a very small anarchy point. In 142 at the end, it says retailers. Is it retailer singular or retailers?
Retailer.
Because it was only Deckers. And
sport pursuit.
Well, you're adding a bit of a gloss. It's not what they found. You may be right. It's not in the facts, is it, that it's retailer as opposed to retailer?
Well, there was no evidence that I'm aware of that suggested there was
but if we're trying to work out what the cat meant here,
yeah.
I mean, it may not harm you if it's retailers. If they're effectively saying there was no fetter on Deckers or other retailers in the clearance channel, pricing as they wished, that doesn't harm you.
No. No, I'm just answering the factual.
No, mine was just a factual point, because I think you had definitely I got the suggestion earlier that actually it was either just Deckers selling itself at discounted prices through its own website, or selling to Sports Pursuit, or whatever it's called, which overtly sold as a discount.
Exactly.
Yeah.
Yes.
You've shown us this what the cat said about how it disincentivises Up and Running from selling at below certain prices. But is there anywhere where it relies upon this or draws that together to say, well, that therefore fits within the wording of?
Yes, I was going to take you to that now. It's very, very brief. So it's
219. It's just a sentence.
Yeah, exactly. So it's 219, exactly.
And there's nowhere else where it explains how that works.
I don't think there is. I think, well, there's a bit more on, there's nothing else on the meaning of 4A, but there's some, when we have, if you go to page 219, for example, this is under supposedly under legal and economic context. There is some discussion of this, and so, for example, you see at 202, the COVID stockpile created an incentive to depart from the tacitly agreed approach by which it and other retailers had historically priced residual stock. Now, I'm sure that's not saying that there was a tacit agreement between members of the selective distribution network. I'm sure that's not what the tribunal meant, because there was no evidence of that. But in any event, we then go through to 203, where you see the same reasoning. It was therefore inevitable that if Up and Running were permitted to sell residual stock on a clearance basis, it would do so at prices which were materially lower than in its own stores or on its website. That must have been obvious to Deckers. Note, it doesn't make a finding that they would sell at a lower price than Sport Pursuit or Deckers itself. And then you see, and this is another legal error at 204, where an agreement gives a party wide discretion whether to pursue an anti-competitive object or a pro-competitive one, it's open to the court to find a restriction by the very nature of the breadth of the discretion. And you see, and so that's because the existence of the discretion undermines the argument about pro-competitive purpose. Now, the case that's cited is Super League, but they've completely mangled Super League. I don't think I've got time to go through Super League, but can I just give you the punchline? Super League was a case where UEFA and FIFA had rules which said to clubs, if you want to
well, they had exercised the contractual discretion in the rules to keep out.
Exactly.
Which then led to litigation in Spain, was it Portugal, which then led to the referendum.
Exactly, and so the reasoning was...
It was the exercise of the contractual power.
And the reasoning was, well, to have rules which can prevent clubs playing in other competitions in the market context is obviously liable to restrict competition because you're completely excluding a competitor. But then they said, but we can understand that football might require this. So even though it looks inherently anti-competitive, you could actually have a rule like that as long as you've got objective and clear criteria. There's simply no basis for saying any old broad discretion is an object restriction. And then you see...
But it would be very odd because it would mean every contract
exactly.
which had a power which on one hypothesis could lead to a restriction of competition itself became a restriction of competition. Exactly. Regardless of how it was ever exercised.
Absolutely, and that's why I say this is a bit like competition law by numbers, where the cat's taking various bits from various judgments and adding them all up.
We understand that.
Yeah. Now, then we see at 207, it's well established that indirect means can be employed to ensure the observance of minimum prices. Now, we agree with that. I've said I agree with that. That's the observance of a minimum price, and so they refer to the guidelines there. We agree with what they say about that. And then we see, as we found in our section on key factual findings, Deckers sought to discipline Up and Running by serving a termination notice. But again, we say that you've got my point. I'm repeating myself. And then you see at 209, it's therefore apparent that there was an agreement which in effect prevented Up and Running from discounting as it wished. And we just say simply not. It could discount as it wished. The fact it didn't want to is a separate point. And then you see the reference in 211 to the hardcore restriction. So that is the sum of the reasoning. So I think you've got my submissions on that. That leaves paragraph 4C. So you'll remember that's the hardcore restriction that says the restriction of active or passive sales to end users by members of a selective distribution system operating at the retail level of trade without prejudice to the possibility of prohibiting a member of the system from operating out of an unauthorised place of establishment. I've shown you what the guidelines say about 5C. I just want to show you COTI because that's on point. And that's at Authorities Bundle 3. tab 21, and if we can take it from, I'll cut to the chase. So if
Paragraph 62.
Yes, 60 exactly. Thank you, my lord. So this is the court. So it starts. It's page 971, and there the issue was whether or not you'll recall what the restriction was, that the online sales channel had to be essentially the storefront of the bricks and mortar store. There were requirements as to brand image and so on, and they couldn't sell on third-party websites. And then they're looking at 4B and 4C, and if you take it from 65, could you just read 65 to 69 to yourselves on page 972?
So it's the first few lines of 68, which is...
Yes, exactly. So this is not, that you see at 65, a contrast with a complete ban, which is a hardcore restriction, Pierre Fabre, and then it's the first lines of 68. Even if it restricts a specific kind of internet sale, that's not a hardcore restriction within 4B or 4C. And so that's why the tribunal was wrong about that as well. And so we say that the block exemption does apply to this agreement. Indeed, this kind of agreement is exactly the kind of agreement that should benefit from the block exemption. So that's our ground 3. I think I can take grounds 1 and 2 quite swiftly because we've traversed a lot of what I was going to say. So grounds 1 and 2 I'm going to take together. Both of those grounds allege that the tribunal erred in failing to apply the correct approach in law to the question of whether the clauses infringe competition by object. And ground 1 is that the tribunal wrongly proceeded on the basis that a clause is an object restriction unless it is proportionate to a legitimate aim, so the aim point. And ground 2 is that the tribunal failed to apply the carte bancaire test because it failed to have regard to the economic legal context. Now, if we can go back to the judgment, can I just show you some earlier parts of the judgment, just because I think they're contextually, before I draw together my submissions, they're contextually quite interesting. So if we take it, we're behind tab 10, if we go to page 169, this is under the heading, our findings about the selective distribution system, and you see at 118 the description of the 2 channels. And then at 119, the selective distribution system was put in place for the main retail channel. And so thinking back to Metro and those cases that recognise that it's inherent in a selective distribution system that you stick in the main channel and you don't sell outside it, that's obviously relevant here. And then paragraph 120 sets out some of the features of the selective distribution system. So Hoka likes to position itself as a premium specialist brand that sells high quality shoes. Retailers are selected in accordance with this positioning strategy. But then you see that, and so you see it too, that they're categorised for the purpose of determining what type of product and the range they'll be offered based on, among other things, their reputation, the look and feel of their premises, and their ability to provide pre-sales advice. The lack of transparency in subparagraph 3, I'm going to come back to that, but that's a key reason why the tribunal found that the criteria didn't satisfy the Metro test. And then you see at 4, the range of products that retailers offer to consumers is an element of the positioning strategy. And then at 5, in relation to older stock, the unwritten expectation was that it would be disposed of in a way that didn't unduly threaten the premium positioning and sale of new season product. Now, unclear what the tribunal means here by an unwritten expectation, and I note Mr. Khan veers away from that in his skeleton, says that this finding wasn't necessary for the tribunal's conclusion. If all it means is that the retailers wouldn't do anything to undermine the brand, then that's uncontroversial. But if the tribunal means that there was any restriction on pricing of residual stock, then we disagree, and that's inconsistent with the finding I showed you at paragraph 143. So pausing here, what we see are...
But it's just talking about an unwritten expectation. I mean, I thought it was the point you made earlier. I mean, the unwritten expectation is if you walk into a store and you see Hocker 2026 model, X £100, and Hocker 2025, same model, just a different colour, if that's your assumption that there's nothing changed between the two, it just looks the same, it's just different colour, but half the price, then that would be disposing of residual stock in a way that would threaten the premium positioning and sales of the new season product. I mean, the expectation, the unwritten expectation is that the retailer wouldn't do that because it'd be kind of, I think the expression is used, cannibalisation of its sales of new stock.
My lord, I agree. So it's, you know, but
it's
there is no finding that there is a cartel between the distributors.
Exactly, that's the point I was trying to make.
And it's always been understood that in a selective distribution, self-interest will prevent you from undercutting because you then encourage others to undercut and you earn less and you're less able to defray what may be expensive obligation.
Exactly, that's all. That's the only point I was seeking to
But
make.
in the absence of a finding that there is a cartel or a concerted practice, which there isn't so far as we're concerned,
yes,
there is no such formal finding.
So what? Exactly. I agree. Now, can I just draw your attention to para 124, because this sets out the flaws that the tribunal found in the selective distribution system. And we don't need to go through it all, but it's essentially that there weren't sufficiently objective criteria and they weren't transparent enough. And the reason I'm just showing you this is because they're relevant to the Metro. They're the reason why the tribunal found that Metro wasn't satisfied. We're not challenging that part of the tribunal's judgment.
As you said earlier, Metro, again, going back to the 1980s, it imposed something of a straitjacket upon suppliers. That was the price they paid if they wanted to get that legal certainty.
Exactly.
But I think over the last 40 years, people adopt all sorts of different methods which may not be Metro compliant. Question is there an object restriction or an effects restriction?
Exactly.
Or is it block exempt?
That's exactly the point. Now, if we skip ahead, please, to page 204, we see key findings from the expert evidence. I've shown you the market shares. Can I just make one point? My Lord Justice Green put to me earlier, I think at the beginning of the hearing this morning, that there's a question about whether competitor brands are interchangeable, substitutable. But of course, the fact that they are is baked into these market shares because there was expert evidence which defined the market. Yes, I mean,
Dr. Majumdar does a 5 to 10% snip test, and by definition that tells you that there is a sufficient degree of substitutability for it to be a specialist shoe market. So,
my Lord, yes, precisely. And then if we go to page 207, you see the beginning of the tribunal's legal analysis. So first you can see on 208, it applies Metro and finds that the criteria don't meet the Metro test. And then over the page on 209, this is the start of the analysis of whether the clause restricts competition by object. And just to go through, and I've made some of these points already, I'll try not to repeat myself, but at 62, you see the central question in this regard is whether in the relevant economic and legal context, clause 15 as agreed and applied pursues a legitimate aim, and it's referring again to generics and Pierre Fabre. And I take the point put to me by Lord Justice Zacaroli before lunch that there is this proviso about relevant economic and legal context in the tribunal's wording, but that's why it's so curious that they just don't look at it. Then we
Can I just ask you on the economic evidence? There was no joint experts report. There were.
No, it was, but it was not contentious, I think.
There was an agreement that the tribunal should operate with two market shares, effectively the upstream and downstream specialist shoe markets. And we have in the papers various market share figures for or brand for Hocker.
Yes.
And as we understand it, I mean, this comes out of.
You can see that at page 207 on paragraph 158. So they're low and well below the 30% threshold.
We don't have a list. You can get it from the experts' reports. There's not in the judgment a list of all the rival suppliers. I think it's a reference to 5 or 6 of them. But actually, the experts sort of agree there are sort of 10, 11 suppliers, all with roughly equivalent market shares between sort of 5 and 10 or 11%. I'm just wondering how much dispute there was. For example, in Mr. Majumdar's report, paragraph 124, and
124 of the judgment.
106. No, the report.
Are you looking in the supplemental bundle?
Possibly. Pages. I've got 185 and 187. Just wondering how much of that was in dispute.
I don't think it was in dispute, but Miss Berridge will tell. I wasn't there, so
yeah.
Was it in dispute? No, it was accepted.
At the risk of asking a very basic question, can I just focus on 162, second line, sufficient degree of harm to competition?
Yes.
So, in my perhaps basic analysis, there are 2 ways in which you can look at that. One is, so far as consumers are concerned, there's no harm in the sense that there's no restriction in their choice of product or the prices they would pay for it. There's another way of looking at it, which is that retailers may be prevented from entering this particular business by selling this product because they don't comply with the SDS. Which are we looking at?
The former. The former is what matters. So the former is you're looking at whether there is a distortion of competition in the market, not
for consumers.
Yes, ultimately for consumers or in the process of competition, but that doesn't require, and that.
It can be both, can't it?
It can be both.
Because it was an upstream market wholesale and a downstream
that's
retail.
there. It can be both, but when one is thinking about is competition between retailers distorted, you've got the point that there can be selective distribution systems normally do give rise to intra-brand suppression of intra-brand competition, i.e. meaning precisely competition between retailers of that brand. But that doesn't matter if there's no market power because it's disciplined by the inter-brand competition. And that's the point that we see running all the way through the case law and the block exemption and the recitals I took you to. So any selective distribution system involves some suppression of intra-brand competition.
So looking at it from the perspective of the harm to retailers, they're not harmed because there is inter-brand competition. They don't need to buy this particular product. They can buy a different one and make a profit in a similar way.
So you're not interested in whether a particular retailer has been prevented commercially from doing something that it wanted to do. That's a restriction of commercial freedom rather than a restriction of competition in the market.
Thank you.
Now, where was I? So going back to 162. So we say that's a bit of a mixed bag, but basically this identification of the key question being legitimate aim, that's wrong, and I've made the points on that in relation on generics. Okay, then we go to content of the contractual provision, further down page 210, and that looks at, that's unobjectionable, it just looks at the content of the provision.
Can I just ask about the case law refers to these 4 ingredients: content, object, legal context, economic context. Content in the present case, for us, requires us to find out what the CAT said were the findings of fact about the content of the restriction. Now, in many cases, it may just be the interpretation of a contract.
Yes.
Here it is the interpretation of Clause 15 plus the email with the findings of fact that the CAT made as to its scope. Content is that synonymous with scope of the restriction?
So one point I want to make about that is when you look at the clause and the email on their face, as I say, they're innocuous. And the reason why the CAT found they were not innocuous was because of the way in which they were enforced on this one occasion.
Yeah.
Now, I don't say, and I don't need to say that that's not a legitimate thing for the CAT to have looked at. You can look at how a clause is enforced.
Yeah.
But it's by only focusing on the enforcement of the clause on this one occasion against one retailer, that was insufficient for the analysis you need for an object restriction. Because as I say, what they should have asked themselves is, well, has this clause been enforced against other retailers? Are there other retailers?
Yeah, but they find they don't. It isn't.
It isn't.
So that's why I'm saying, for the expression content, I would say it was, you construe the instruments in question, of which we have two, clause 15 and an email.
Yes.
You would, because we're looking at an AEG type case, a unilateral act in a contractual contract, we're looking at what facts were found as to its enforcement, to which we have these paragraphs 143, the parentheses, and 142. It was limited, focused on one retailer,
Yeah.
one category of goods arising out of one circumstance on one type of internet.
Yes, exactly.
But that's the content.
Well,
'Cause
no,
that defines its parameters, if you like.
well, the content, I mean, to be fair to the tribunal, looking at content, they basically just recite the clause itself.
I know.
So 165 and 166, and all of the other stuff comes into what they, under the heading objective aim. So I think for content, their criticism is that it's a wide discretion, and I've explained the point, the way that I think they've
I mean,
got
I
it.
suspect with both all of these four headings, there is overlap between them. One can't be too mechanical, because content can really be the answer to purpose. Legal context could tell you the answer to economic context. So they're not hermeneutically sealed.
They're not. Or even
Pigeonholed.
hermetically sealed.
Possibly that as well. Hermeneutical because it's language.
sounds better. Yes, but I agree that they're not. There can be overlap. But looking at what the CAT found, so section B, page 211. This is, I've shown you 167 already. This is all about what they thought the purpose of it was, and they rejected Decker's position that it was about signposting of a website back to the main operation. They rejected that on the facts. Quite curious, because of course signposting is tied up with brand recognition and so on, which is the tribunal's accepted as part of the selective distribution system. But anyway, let's leave that because it's a finding of fact. And then if we go over the page to page 213, or rather, sorry, if we look at 172, so the above conclusion shouldn't be interpreted as meaning that having a channel specialised in the heavily discounted and out-of-stock products is necessarily inconsistent with the protection of a supplier's brand image. Now that's curious, because it seemed up till this point that the tribunal was very much against that and thought that not allowing entry into that channel is anti-competitive. And it goes on to say it doesn't mean either that suppliers can't impose limitations concerning entry into a specialised channel in the name of brand protection. But they go on to say that that's not what's going on here, because Hocker hasn't shown that this has been done in the name of brand protection. And my submission about where this has gone wrong, this part of the reasoning, is that essentially the tribunal is here applying a Metro analysis. Metro does require the court or the authority to look at whether or not the brand image aims of a measure are legitimate and whether the restriction is proportionate to that aim. But that's not an essential part of the object assessment. And in fact, you can see the error crystal clear in para 175. Were Deckers to have been operating a well-constructed selective distribution system without the defects identified in para 124 above, and you'll recall that those defects lack of transparency, etc., were the ones that led the tribunal to find that Metro did not apply. We may have been open to argument that the obvious inherent impact on price was not the primary objective, and there were other legitimate aims arising from the selective distribution system. Now, 2 points which would rebut any categorisation of the contractual provision as by object restriction. Now, 2 errors here. One error, well, it's really the same error. What the tribunal is effectively doing is applying the Metro test. And we know that you can fail the Metro test and not be an object restriction. But and secondly, and relatedly, they're saying in order not to be an object restriction, you have to have a legitimate aim. And that's just not the law. So that really sort of crystallises the error.
I've just picked up in 174. That's the reference to legitimate impact on price.
Yes, exactly.
From Pierre Fabre and
That's
AG.
right. AG, you referred to that, my lord. That's correct. And so 178, they say, when considering the objective of a provision, it's permissible to look at the way it's been operated subsequently. Well, that's true, it's permissible, but that's not the only thing that you should be looking at. And then you see at, this is all under the heading, this is under the heading objective. Then you have the heading legal and economic context on page 216. And it's really more of the same, you've seen it. And again, we just make 3 points, and I am now repeating myself. We say that there's nothing in this section about the small market share of the parties, nothing about interbrand competition, who are the other players, is interbrand competition strong, nothing about whether there was any demand from other retailers for websites with names not associated with their physical stores. If there's no demand, then that suggests it's not a problem. It's not a thing that people want. No analysis of the fact that this was a one-off COVID niche situation. And so, in other words, no real analysis of whether the clause was likely to have any impact at all on competition in the market, simply not addressed. Second point is what the tribunal did address in this section was whether the clause had a legitimate aim.
Does the mere fact that it's like a one-off blip or whatever necessarily take it outside having an effect upon the market?
Yes, I think it does, especially where, it really does make it a niche one-off issue. And so,
but I suppose does it depend upon the nature of the product, perhaps?
It might depend on the nature of the product, or particularly on market shares. And so, if they had a very, very powerful market share, and it was a product which was a must-have product, then one might think, well, this is a market that's heavily dependent on this brand. The retailers are dependent on it. That there's not sufficient inter-brand competition. And so this matters more. But it really is just my point is that it's a temporary limited issue. There was evidence that there was just no demand from the other retailers in the selective distribution system for this. And Up and Running have been perfectly happily selling Hoka products. It was really only because of the surplus as a result of COVID that they wanted to set up this channel. So it was a time-limited issue.
Was there any evidence of the total number of pairs of shoes affected by the restriction as against the total number of shoes in the defined product market? Are we talking about a few hundred or a few thousand pairs of shoes against the total?
Yes, so because, Ms. Berry, I don't think there's direct evidence, but because Up and Running were the only company that wanted to do this, you can look at their market share.
But that doesn't tell you, we've got the market share figures for their total sales.
And it's going to be
It's going to be a portion of that.
I don't know the exact.
And if it's a temporary portion, the analysed figures don't necessarily tell you what that portion is as against the total number of shoes being sold.
And it's likely to be tiny, just looking at the market shares, and it's just something which wasn't addressed by the tribunal and should have been. Now, the second point is that what the tribunal did address, the only thing it focused on was whether the clause had a legitimate aim, and you see this throughout this section. So if you look at paragraph 190, this is all in the context section. Can't be said that this pursues a legitimate aim. And then 193, again, legitimate aim. And then 194, rejected signposting, no other legitimate justification. And that sole focus on legitimate aim is inconsistent with carte bancaire. Third, the tribunal purported to see whether there was experience in the case law of similar clauses. We see that at 195 and 196. And in fact, Coty is the closest case on its facts, and it supports us. And Metro and AEG are not examples of cases concerning this type of clause at all. And so we say that the tribunal has not carried out the carte bancaire analysis, and that it's obvious in our respectful submission, given the small market shares, that this clause does not distort competition in the market at all, let alone to the serious degree necessary in order to give rise to an object infringement. And I think what's happened here is that the tribunal fixed on this theory about pricing, and that's then affected its conclusion, but it lost sight of the fact that the agreement between Deckers and its retailers permits them to sell online and permits them to sell at whatever price they want. And it lost sight of the fact that selective distribution systems are generally pro-competitive. They're the means through which brands can compete effectively against each other to try and win market share. And that softening or lowering of price competition is inherent in every selective distribution system, but it generally doesn't matter. So, my lords, those, unless you have any further questions, those are my submissions, and we respectfully ask the court to determine that this agreement falls within the block exemption and is, in any event, not an object infringement of the competition rules.
Thank you very much indeed. Mr. Armitage.
May it please the court, I propose to begin with a few short preliminary remarks about the CMA's role and interest in this appeal, and then address you on 4 topics. And those are, first, I'd like to say something briefly about the published CMA guidance, which we say is germane to the issues in this appeal. Mr. Micio has covered some of that already. Secondly, I'd like to address you on what the CMA respectfully submits was the tribunal's core error of principle in articulating the test for an object infringement. Of course, that does overlap heavily with the submissions you've already heard, and I'll endeavour to confine myself to supplementary points. And in particular, I'd like to show you 2 or 3 authorities to which you have not been taken so far today, but which bear on the appropriate analysis. Thirdly, I'd like to say something specific about the relevance of market shares and market power to the assessment of whether agreements restrict competition by object, in particular picking up some remarks made by my learned friend Mr. Khan in his written submissions. And in particular, I'm going to show you what the Court of Appeal said about that issue in the Gascoigne-Howman case, which you haven't seen thus far. Those 3 topics all relate principally to ground 1 of the appeal. And then fourthly, I'll address you very briefly on a discrete issue concerning the overlap between the concept of a restriction by object and the concept of a hardcore restriction under the block exemption. That point arises as a result of Mr. Khan's, my learned friend Mr. Khan's response to a point that the CMA has made in relation to ground 2 of the appeal. So those are the 4 topics. As the Court of Appeal knows, the CMA has not sought permission to intervene in respect of ground 3 of the appeal, and so I won't address you on that orally. In terms of brief preliminary remarks, as we note in our written submission at paragraph 1, under the legislation which established the CMA, and in particular under section 25 of the Enterprise and Regulatory Reform Act 2013, the CMA was entrusted by Parliament with the duty to seek to promote competition, both within and outside the United Kingdom, for the benefit of consumers. As we note in our written intervention at paragraph 1, it also has a duty to prepare and publish general advice and information about the application and enforcement of the Chapter I and II prohibitions. That's section 52 of the 1998 Act. And as well as its public enforcement work, the CMA also intervenes in private competition law litigation. As you know, the CMA has a specific right under Practice Direction 52D to make written submissions in any appeal to the Court of Appeal raising Chapter 1 or Chapter 2 issues, and the CMA is grateful that in the present case, the Court of Appeal has also permitted the CMA to make oral observations. And now, this point will be unsurprising, but the CMA does wish to emphasise at the outset that its sole interest in this appeal is to ensure that the appeal is determined in accordance with the correct legal principles. It is entirely neutral as between the two parties to the dispute, and as its conventional approach when intervening in private claims, it takes no position on the tribunal's assessment of the evidence, nor does it express any view on whether any error of law made by the tribunal was material to the outcome. Our focus is on the legal test. In that regard, we do say that the CAP fell into error in its articulation of the overall approach to the assessment of infringements by objects. That is obviously a matter of significant importance to the CMA, given its public enforcement work, both in relation to selective distribution agreements and in relation to Chapter I more generally. Turning then to my first topic, which I have under the heading Relevant CMA Guidance. The CMA has published two pieces of guidance which we say are of relevance to the issues in this appeal. The first is the July 2022 Vertical Agreements Block Exemption Order CMA Guidance. You have that at Joint Authority 6, tab 36, page 2177. And that's the document that's going to hereafter be referred to as the snappy little document, as Lord Justice Green described it. Mr. Demetriou has already taken you to this, but if I may, I'll say a little bit more about it. Now, as its title suggests, the guidance followed the entry into force of the Vertical Agreements Block Exemption Order, or VABIO, which came into force on the 1st of June 2022, replacing the EU Vertical Block Exemption for the purposes of the United Kingdom. Despite its title, as you've already seen, the guidance does not only focus on the position under the block exemption, but also explains more generally how the CMA applies the Chapter I prohibition to vertical agreements, including specifically in relation to selective distribution systems. It was not cited in the judgment below, but I would respectfully commend it to the Court of Appeal in relation to the approach to analysing these sorts of issues. In our written intervention at paragraphs 11 to 16, no need to turn it up, but you have that at Core 7, page 96. We have sought to distill from Chapter 10 of the guidance a three-stage approach for assessing whether a selective distribution system or a clause within such a system contravenes the Chapter I prohibition. And very briefly, that involves asking first, does the system satisfy the metro criteria? If so, you fall outside the scope of Chapter I altogether, and that's guidance paragraph 10.88. Not an issue on this appeal, of course. Secondly, in the sequence, at least under the guidance, one asks, does the agreement qualify under the VABIO? As you know, the VABIO was not in force at the time of the facts in relation to this appeal. But as a matter of generality, we say that's the sensible second stage. And then the third stage, arising where the agreement neither satisfies metro nor qualifies for block exemption, is what the vertical guidance describes at paragraph 10.17 as a full competition analysis. And in my submission, what that entails, what that must entail, is deciding whether the agreement restricts competition by either object or effect, applying what are now a well-established set of legal principles to that question. Pausing there, we understand it to be common ground on this appeal that there is no presumption that a selective distribution system which fails to satisfy the metro criteria constitutes an infringement of competition law by object. The tribunal so held at judgment paragraph 41. In my learned friend Mr. Khan's skeleton argument, there was a suggestion that the tribunal may have taken a position more favourable to Deckers than the case law of the Court of Justice arguably allows. But in its response to the CMA's intervention, the respondent has confirmed that whatever the earlier case law may have suggested, the position following carte bancaire is that non-compliance with metro does not mean without more than SDS thereby infringes Chapter 1. So that is all happily common ground.
Your batting order of metro, VBO, and then object or effect, that's really a matter of convenience rather than pure theory, isn't it? I mean, logically you'd say, does it fall within the prohibition at all? Well, if it does, then we get out because we're metro and or because we're block exempt. But it's a convenient way of looking at it.
Indeed, that's as far as we go.
Yeah.
And in fact, that picks up a point made in the respondent's response to the CMA's intervention, in which my learned friend describes the three-stage approach we've sought to distill from the guidance as simultaneously pragmatic and odd. And we say yes to pragmatic and no to odd.
Well, you don't care if it's odd. If it's pragmatic, you don't care if it's odd.
Well, that may be a better way of putting it, my lord. But yes, as Mr. Demetriou has already said, The block exemptions, the vertical block exemptions, are supposed to be easy for businesses to apply, and we saw that in the CMA recommendation that she took you to. But as you say, my lord, we don't suggest this is a mandatory order for the analysis. We don't suggest that the tribunal below, or indeed the Court of Appeal in Ping, made a legal error in considering the matter in different steps. It's simply, we respectfully say, a convenient way to apply and distinguish the separate conceptual stages. Just to show you one specific paragraph. So as I say, the guidance refers to the need to do a full competition analysis where you are outside Metro or the block exemption. And Mr. Mitriou showed you earlier what the guidance says about how that full competition analysis is to be conducted in relation to selective distribution agreements, and that is at paragraph 10.93 of the guidance, which you have at authorities.
Tab 36.
Tab 36, page 2291. Yep. And I only take you back to this because Mr. Mitriou said, and sorry, that's the paragraph that refers to the need to think about the market position of the supplier and also the number of selective distribution networks present in the same relevant market when you're considering compliance with Chapter 1. Mr. Mitriou said this morning that the guidance is here focusing on an effects analysis, but the CMA doesn't actually read its own guidance as being limited in that way. It's true that it doesn't here distinguish between an object or an effect analysis. What it's doing in my submission is picking out the sorts of factors that need to be considered in relation to any analysis of whether an agreement of this kind complies with Chapter 1, albeit no doubt with greater intensity in relation to the effects analysis, and we'll come back to that. In fact, I'll show you in a moment another piece of CMA guidance that does address more specifically the features of an object assessment. In fact, I'll go there directly. So that's the so-called horizontal guidance, which you have at Authorities, Volume 6, Tab 38, August 2023. And while that is entitled Horizontal Agreements Guidance, I rely on what it says about restrictions of competition by object generally, in circumstances where it is common ground on this appeal, as we understand it, that the same basic approach applies to the assessment of whether vertical agreements restrict competition by object, as it does to the assessment of horizontal agreements, subject to the general recognition in the case law, as Dimitri has already referred to, that vertical agreements tend to be regarded, at least as a matter of generality, as less injurious to competition than horizontal agreements. And if we could go, please, to page 2433, paragraph 3.36 of the guidance. This is now obviously very familiar in the context of this appeal, but we see the CMA there sets out the correct legal approach to the assessment of whether an agreement restricts competition by object, the reference to the need to analyse whether an agreement reveals in themselves and with regard to their content, objectives and context. So that's the three-stage test, and that aligns legal and economic context in that third factor. But the overall test is sufficient degree of harm to competition, such that it's not necessary to assess their actual effects. And just for your note, we see at footnote 50 the citation for that statement of the correct approach is the CJU's judgment in generics. And we say that reflects the fact that, as my learned friend Mr. Mitriou has already said, and we agree, generics was itself a perfectly orthodox approach to the object assessment and did not establish some new variant of the legal test based on the presence or absence of a legitimate aim. I should say that at one point this morning, Mr. Mitriou, I think in discussing the vertical guidance, or perhaps at a different point, used a formulation which focused on whether a clause was likely to have any impact on competition in the market. My understanding was that Mr. Mitriou was not seeking to suggest that the object analysis involves any attempt to assess the precise likelihood or magnitude of any effects, and I see her indicating her agreement to that. And I should say, although not an issue on this appeal, even an effects analysis does not require precise quantification of, for example, the impact of a particular agreement on price. It's typically only when one gets to a damages assessment in a private claim that you end up with the kind of complex regression analyses so beloved of competition lawyers and economists. So when one distinguishes between the objects and effects analysis, and describes the latter as we hear sometimes as a full-blown analysis. It's important to remember that the effects analysis also has its own features and limitations, but those are happily not an issue on this appeal. Turning to my second topic, the CAT's core error of principle. As I say, that's the subject matter of ground 1 of the appeal, and I don't propose to repeat the points made by Mr. Dimitriou, say to make clear what the CMA agrees with. We say that, in short, what has happened in this case is that the CAT has taken one of the relevant factors referred to at paragraph 3.37 of the guidance, so content, objectives, and economic and legal context. It has taken the objectives factor and elevated that to the status of an overall test for whether there is an object infringement. And we respectfully agree with Mr. Dimitriou that as a statement of the legal test, paragraph 46 of the judgment gets this wrong, and the CMA's horizontal guidance gets it right. And put another way, the essential error is to treat the presence or absence of a legitimate aim as the decisive factor, rather than what it actually is, which is a highly relevant and important consideration, of course. You see the same error, or a version of the same error, at paragraph 48 of the judgment. That's the word necessarily that my Lord Justice Green alighted on earlier. Now, when we made this point in our written intervention, the Respondent suggested at paragraph 13 of its response to the CMA's intervention that the CMA had not understood the judgment correctly. But we say with respect, there's really no ambiguity about what the CAT is saying when it articulates its legal approach at, for example, paragraph 46. And could I also just show you, I think you were taken to this, but it's paragraph 175 of the CAT's judgment, which you have at tab 10, page 213.
Sorry, I was writing. Can you give me the reference again?
I think it's core tab 10, page 213, paragraph 175.
Yep, thank you.
I think Mr. Dimitriou did show this, but just to go back to it briefly. The CAT says, were Deckers to have been operating a well-constructed selective distribution system without the defects identified, we may have been open to argument that the obvious inherent impact on price was not the primary objective and that there were other legitimate aims arising from the system, which would rebut any characterisation of the contractual provision as a by-object restriction. In other words, the CAT appears to be saying that if Deckers had shown that there were other legitimate aims, that would be decisive against the finding of an object infringement. And a friend, Mr. Khan, suggests in his written response to the CMA that this paragraph is obiter. Whether or not that's right, we say the point is that it betrays the same basic error of principle as we see at paragraph 46. Mr. Dimitriou has obviously articulated why that is an error of principle. I would, if I may, just like to show you a couple of additional authorities bearing on this point. They are the bids case in the CJEU, the judgment of the tribunal rather than the rather than the Court of Appeal in Ping. I want to also say a very brief word about the Cabo case, but Mr. Dimitriou has largely addressed you on the points I have proposed to go to in relation to that case. Starting then with the BIDS case, BIDS standing for Beef Industry Development Society, you have that at Authorities Volume 2, tab 17. So this is a decision, a 2008 judgment on a preliminary reference from the Irish Supreme Court. It's cited by the Court of Appeal in the Ping case at paragraph 94, which I don't think Mr. Dimitriou showed you earlier. Briefly, the facts may be familiar to some. It concerns a society set up to address a problem of overcapacity and consequent impact on profitability among Irish beef processors. And in essence, the arrangement was that the so-called stayers, those who were staying in the market, would pay a levy, which would then be used to compensate what were known as the goers for effectively exiting the market. And the goers comprised approximately 25% of the capacity in the market. And as the Court of Appeal observed in the Gascoigne-Howman case, which I'm going to come to a little later, when discussing this case, it's perhaps unsurprising that arrangements that involve paying a significant proportion of your competitors effectively to leave the market should have been considered to be a restriction of competition by object. The society nevertheless sought to defend itself against the charge of restriction by object, arguing that it was pursuing a legitimate objective and in particular seeking to remedy the effect of a crisis in their sector. And if we could go please to paragraph 19 of the judgment, which you have at page 819. You will see the argument that BIDS was seeking to run in defence of the charge of restriction by object. I've just summarised, and then at 20, that argument cannot be accepted. And then at 21, if I could just invite you to read that paragraph, particularly the red text with the red sidelining. And it's particularly the words, an agreement may be regarded as having a restrictive object even if it does not have the restriction of competition as its sole aim, but also pursues other legitimate objectives. In other words, the presence of a legitimate aim cannot save an agreement from being, cannot in itself save an agreement from being regarded as restricting competition by object. By the same token, the Court of Justice did not say, well, this agreement pursues an anti-competitive aim, which it clearly did. That's the end of the inquiry. Rather, if one skips ahead to paragraph 40, following analysis of the particular provisions, you'll see the Court of Justice, and this is page 822, paragraph 40. The reply to the question referred must be that an agreement with features such as those of the standard form of contract concluded between, and then the 10 principal beef and veal processors in Ireland, so reliance being placed on the importance of the process to whom the arrangements apply, and then requiring, among other things, a reduction of the order of 25% in processing capacity. So that is clearly an example of the tribunal looking at features of the economic context and not just the aim pursued in order to establish whether the agreement restricts competition by object. Now, of course, the CAT did say at paragraph 46 that one needed to look at features of economic context, and it didn't ignore that factor in this sense when stating the legal test. But we say that it got it wrong because what it said is that you look at the features of economic context in order to decide whether an agreement pursues a legitimate aim. We say respectfully that airbrushes out the overall test, which is always, does the agreement reveal a sufficient degree of harm to competition that it's unnecessary to examine its effects. And the problem with the CAT's approach is that you may have cases in which the agreement considered in its context does pursue an anti-competitive aim, but nevertheless the context reveals it isn't capable of having a material impact on competition. And that's a point, just for your note, made by the Advocate General Terstiniak, in the BIDS case itself. I don't propose that we turn that up, but we see that paragraphs 50 to 54 of his opinion, Authorities, Volume 2, tab 17, page 804. And the same basic point about the importance of context is made by the Court of Appeal in Ping, at paragraph 97, Authorities 1, tab 11, page 402. You saw that earlier. That's where the Court of Appeal quoted the Advocate General in the Alliance Hungaria case, I think, and that was the reference to outright incapable. My Lord Justice Snowden picked up on that point from the Advocate General and referred to the language of a rough and ready assessment. And we also, I'm sorry, I think that was my Lord's language.
Yep.
We do see, though, another phrase, the basic reality check in some of the cases.
Yep.
And from the CMA's perspective, the CMA has no particular issue with that as a description of what the object analysis may entail in practice. Although, of course, the legal test is as stated in Carte Bancaire itself. Certainly where one has a very suspect form of arrangement, if I can put it like that, horizontal price fixing or paying a competitor to leave the market or something of that nature, the inquiry into economic or legal context may be a very basic reality check, but the point is you still need to do it. Where in contrast you have a less familiar form of conduct, something that has not previously been put into the object box, a more detailed examination of context may be called for, but that inquiry may nevertheless reveal a sufficiently serious degree of harm to competition for the infringement to be characterised as a restriction by object. But really, it depends on the facts. And we say what you cannot do is dispense with context altogether, or elevate the question of legitimate aim to the status of a decisive factor. And
Would it be fair to say the depth of the analysis required is proportionate, in some respects, to the decisional practice developed over many years? So,
yes,
a number of the cases say, well, horizontal price fixing, generics, dominant pay for prevention, they're obvious. They're well established in case law. You don't require a huge amount of evidence.
yes,
You distinguish between horizontal and vertical. When you move into the vertical, you are innately less likely to have a restriction, almost in principle, because it's vertical, not horizontal. And therefore, there's a greater requirement, though even then it's going to depend upon the facts. But when you get down to, I think what Mr. Dimitri says, something which is very narrow and confined, if you're going to establish object, then commensurately the burden is greater. So it's a sort of a shifting burden along a scale. The scale is partly determined by decisional practice or an SBO, statement of the be obvious.
yes. I don't think I demur from any of that. In fact, I think that's effectively the submission I was seeking to make. I mean, it's hard to generalise about these matters. I mean,
It is.
For example, you may have
It's dangerous to generalise.
dangerous to generalise.
It's always fact and context specific.
It is, of course. To give one example, you may have a form of conduct that at one point in time is not in the object box because, as my lord says, there's been no prior decisional practice. And in fact, when the pay for delay cases started to come through, that is no doubt why the early cases engage in what looks like a pretty intensive inquiry into context, survey and so on. As time goes on, it may be that one establishes this decisional hinterland, if you like, and it becomes less necessary to do that. On the other hand, you may have what looks on its face like a novel form of practice or something that appears in a novel AI or something. But actually, when you look at it, get under the bonnet a little bit, it's so obvious, SBO, as my lord puts it, that it's a conventional form of infringement, albeit one in a novel industry, that, again, nothing more than a basic reality check is required. But it really does all depend on the context. That's a point, incidentally, that is made in terms in the opinion of Advocate General Emilou in the CD Tondela case from May of last year. I think my Lord Justice Green directed the parties to that last week. I don't want to turn that up, but you have that at Joint Authorities 4.
I don't think the judgment's out yet, is it?
I don't believe so, but the Advocate General, and it's at paragraphs 33 to 36 and 42, draws that distinction between the depth of the inquiry in an object case, depending on how familiar, if you like, the category of infringement is. So that's all of a piece. Briefly then, so that's bids. Briefly, I'd like to show you the tribunal's judgment in Ping. You've of course seen the Court of Appeal judgment. You have that at Authorities 1, tab 8. Sorry, you have the CAT decision at Authorities 1, tab 8. It isn't cited in the written submissions, I don't believe. We just wanted to draw it to your Lordship's attention because it contains, we say, a very clear analysis of the very point that arises on ground 1 of the appeal. So if you could look at page 259 of the bundle, paragraph 92, subparagraph 1 of the judgment. If your Lordships have that, this is summarising Ping's case on the law with regard to infringement by object. And Ping starts by saying, unobjectionably, the essence of an infringement by object is that it reveals in itself a sufficient degree of harm to competition. It's not sufficient to establish an infringement of competition by object to find merely that the activity or behaviour in question is activity or behaviour of a certain type or that restricts commercial freedom of action. What is needed is an assessment of whether the rationale or purpose of the agreement is plausibly pro-competitive or not. And that we say is redolent of the CAT's characterisation of the legal test in the present case, paragraph 46, so focusing on the presence or absence of a plausibly pro-competitive aim. And then if you could move on, please, to paragraph 101 of the CAT's judgment. We'll see what the CAT makes about that. That's at page 264. you'll see that the argument is rejected emphatically. We do not accept Ping's submission that the presence or absence of a plausibly pro-competitive rationale is the key to identifying an infringement by object. That submission simply does not reflect the law as stated by the Court of Justice in Competition. Had the Court of Justice considered it appropriate for national courts to limit their consideration as to the plausibility of the rationale underlying the relevant restrictions, it would have said so explicitly. And consistently with the submissions I've made, the tribunal in Ping says that this approach cannot be reconciled with the Court of Justice's judgment in the bids case. Now, obviously, that is not binding on you. We say it does reflect a different approach to the approach taken by the tribunal in the present case, and that this is the correct approach, and we invite the Court of Appeal to clarify that in its judgment. Now, these authorities are dealing with, in a sense, the converse of the present situation, because they're asking whether the presence of a legitimate aim vitiates the finding of restriction by object, and make it very clear that it does not. But we say the converse point is also clearly correct. In other words, that the absence of a legitimate aim does not in itself constitute a restriction of competition by object. I've been going to take you to the Cabo case in support of that point. I'd even prepared a joke about it being the sort of case in which my 6-year-old daughter should have been called as an expert witness, but as Mr. Dimitriou has already covered the case, I'll spare you the joke, and I'll just briefly touch on what Mr. Khan, Learned from Mr. Khan, says in his response to our intervention, in which we had referred to this case, which I believe postdated skeletons in this appeal. Mr. Khan says that Cabo is uninformative because the economic context of that particular case is, to use his word, extreme. That's paragraph 14C of his response to the CMA. Now, the CMA doesn't express a particular view on the extremity of the facts in that case, or their comparison to the facts of the present case. We simply rely on Mrs. Justice Bacon's approach as accurately reflecting the law. It shows why it is wrong and can result in error if one treats the presence or absence of a legitimate aim as decisive, just as the Court of Justice emphasised in the bids case. It's wrong, in short, because there's a risk of a false positive, an incorrect finding of an infringement by object in relation to an infringement that simply isn't, an agreement that simply isn't capable of restricting competition at all. But I emphasise we're not saying anything here about whether that is an apt characterisation of the present case. The only other authority I'll just mention is the Commission's, under this topic, is the Commission's 2018 decision in the Guest case, which is discussed in the judgment below. In the interest of time, I don't propose to turn it up, but the relevant references are Joint Authorities 5, tab 32, page 2008, and its recitals 114 to 126, where the Commission explains why what's referred to as an online search advertising restriction, which is all to do with Google AdWords, amounts to an infringement by object. And the short point when one looks at those paragraphs is that just as in Cabo, the Commission finds that there is no legitimate aim, indeed there's an evidently anti-competitive aim, but it doesn't stop the analysis there. It proceeds to consider whether the agreement assessed in its context reveals a sufficient degree of harm to competition. In other words, the overall test as stated in Carte Bancaire.
Is that paragraph 124?
I'm so sorry?
Is that paragraph 124?
So I have 118 to 119 on the question of whether there's a legitimate objective, and then 123. Let me just turn it up. Yeah, so this is page 2008. Sorry, yes, exactly. So 123 is...
it's 124, isn't it?
You're quite right, I'm sorry. So 123 is the finding that the restriction did not pursue any other legitimate objectives. And therefore, there's no need to assess whether the prohibition is appropriate or whether it goes beyond what is necessary to achieve that objective. That's a reference, I think, to the Metro criteria. But then, as you say, my lord, you're quite right. 124, it is necessary to determine, however, and then a statement of the overall test. And then... learned from Mr. Khan rightly makes the point that the Commission's actual consideration of the economic context in this case is quite limited, and to be clear, the CMA accepts that the analysis of, I think I made this clear earlier, accepts that the analysis of context need not be extensive in an object case, but everything will depend on the facts. Again, the point is one has to consider it somewhere in the analysis. Very briefly, just on the generics case, before I turn to my next topic. CMA respectfully agrees with what the appellant has said about generics. That is, that it doesn't represent a change in the approach to the assessment of object infringement, but rather is fully consistent with carte bancaire, and indeed it cites carte bancaire without any suggestion that it's departing from it. Learned friend Mr. Khan suggested in his response to the CMA's observations that it was unclear whether the CMA accepted or didn't accept that generics articulates a different approach that focuses on the absence of a legitimate aim. I hope there was nothing unclear about the CMA's position on this in writing. I don't propose to go there, but I'll cite paragraphs 27 and 29 of the CMA's written observations, core tab 7, pages 103 to 104. In its response to the CMA's intervention, the respondent also refers to the fact that the CMA was a party to generics and notes that the CMA did not object to the way in which the CAT formulated the issue of restriction of competition by object when the matter was remitted to the CAT after the CJEU's judgment. Well, it's right, of course, that the CMA didn't object to the statement of the law by the CJEU, couldn't have, but the premise of that submission is obviously that the Court of Justice in generics did indeed introduce a different approach, and we say it didn't. I'd also, just again for your notes, we've included the CAT's judgment of tribunal presided over by Mr. Justice Roth before the case was referred, in fact the judgment in which the case was referred to the CJEU. We have that at authorities 1 to 7. I'll just refer you.
Sorry, I sneezed. Sorry, can you say that again?
Inconveniently sneezed. Bundle.
Authorities, volume 1, tab 7, page 153. And that is another articulation, in this case by Mr. Justice Roth and his colleagues in the tribunal, of the approach to object infringements and the need for, as he puts it there, consideration of potential effect in the overall market context, albeit as distinct from the sort of analysis that would be required in an effects case. So it's another illustration of this point about how you do the analysis, but it's just there for completeness and doesn't take matters further. Was going to go to TIVA, which the CMA had included in the authorities, but again, Mr. Mitchell has addressed that case, and I don't need to say anything else about that. Turning then to my third topic, this is just some short submissions on the relevance of market power, market shares, to the object analysis. Now, when we've talked about market power in this context, no one is suggesting that is market power in the sense of dominance. It's not obviously a prerequisite of a finding of an object infringement that you have a dominant position. I don't think anyone suggested that. It is important just briefly to say something about this, given what has been said by the respondent in the written materials. Now, in carte bancaire, as Mr. Michu, I think, showed you earlier when looking at Ping in the Court of Appeal, Advocate General Vaal observed, when emphasising the importance of economic and legal context, that even a horizontal price-fixing cartel might escape characterisation as a restriction by object, where the undertakings concerned hold only a tiny share of the market concerned. The learned friend Mr. Khan says in his skeleton argument at paragraph 4 that this is irreconcilable with the case law. Now, the CMA, as the statutory competition regulator, would certainly agree that where one sees a restriction of competition, such as potential restriction of competition, such as horizontal price fixing or indeed vertical price agreements, it may be very likely that will end up being characterised as a restriction of competition by object. Now, in fact, if two businesses are engaging in price fixing of that kind, it seems likely to be because they perceive that it will have some impact on the market, or else why would they go to the effort? What that may tell you is that, in fact, there is a market, it may be a small market when properly defined, in which market shares are not, on proper analysis, tiny at all. But those matters we respectfully suggest are best left to be considered by reference to the facts of particular cases. On the other hand,
I think Advocate General Emilio also referred to price fixing as an example of something which, in extremis, might not amount to an object restriction.
Yes, exactly. On the other hand, insofar as the respondent seeks to suggest that market shares are not relevant to the question of whether an agreement or clause involves a restriction of competition by object, such a suggestion would not be correct. I've already taken you back to paragraph 10.93 of the CMA's vertical guidance, the snappy document, which emphasises the need to consider the market position of the supplier and its competitors. And my submission, the relevance of market power to the assessment of whether an agreement restricts competition by object was unambiguously confirmed by this court in the Gascoigne-Halman case, which I'll show you briefly. That's at Joint Authorities 1, tab 9. Briefly, to summarise, this was a case about an association of estate agents which launched an online property portal called On the Market, which was effectively envisaged as being a rival to some of the more established and well-known portals like Rightmove. And it had a contractual term, effectively a condition of membership, called the One Other Portal Rule, which said if you wanted to list your properties on the market, you could only list them on a maximum of one other portal. And it also operated various other rules which are not material for present purposes. The CAT held that this was not a restriction of competition by object, and the Court of Appeal upheld that finding on appeal. And I only rely on it for what is said about market shares. And if we could look, please, at page 350, paragraph 49. Just to situate this, paragraph 47, Court of Appeals, not persuaded by the criticisms advanced of the CAT's conclusion that the One Other Portal Rule did not represent a by object restriction, so findings that it didn't restrict competition by object. And then it's the second point at paragraph 49, which relates to legal and economic context. The CAT addressed this in the judgment, noting, among other things, agent mutuals and on the market's lack of market power, and various other factors, including barriers to entry and so on and so forth. The CAT was clearly correct to take account of such matters, cites reference to economic and legal context in carte bancaire, and also a reference to the significance of market power from the Allianz Hungaria case, and then also in the Commission's horizontal guidelines. And then, just to complete the picture, one goes on to paragraph 59, which is the conclusory paragraph. Coming finally to the CAT's overall assessment of the One Other Portal Rule, it seems to me that it was fully justified in concluding that the rule was not a restriction by object. Given the rule's nature and the specific legal and economic context, including in particular agents mutual's lack of market power, it was entirely legitimate to consider that the rule did not reveal a sufficient degree of harm to competition, that it was unnecessary to consider its effects. And then there's a reference to the rule falling into Advocate General Turstenak's category of cases in which an agreement is ambivalent, and I referred you to the relevant paragraphs of that opinion, and that's the bids case, which I took you to. In its response to the, so we say, just to round that off, that is extremely clear authority, that in order to assess whether a given restriction infringes competition by object, market power of the counterparties is clearly a relevant consideration. Now, in its response to the CMA's written observations, the respondent suggests that the CMA has conceded that modest market shares are not a contextual element that can vitiate a characterisation of certain restrictions as a restriction by object, and says that this concession is unavoidable as regards both RPM and restrictions on internet sales. And it refers to some CMA guidance on that point, and that is at the respondent's response to the CMA, paragraph 14A, 4, tab 9, page 123. For the avoidance of doubt, as I hope is now clear, the CMA does not concede that modest market shares are incapable of vitiating the finding of restriction by object in any particular case, even for something like RPM, as my Lord has just said. It will all depend on the facts of the case. Importantly, the case will typically involve multiple relevant contextual factors. No single factor may be decisive, and what's required is an overall assessment of the economic and legal context, looking at the real conditions of the market concerned. Depending on the facts, that may include market shares, it may include a consideration of the importance of the retail channel in which prices are restricted, it may include looking at the market coverage of the impugned agreements, and so on and so forth. No doubt, as I've said, something like RPM will very commonly constitute the sort of serious restriction that amounts to a restriction of competition by object, but it is wrong to say that merely because you have found a vertical agreement containing a clause that looks like RPM, it necessarily follows that it is a restriction of competition by object. That would be contrary to the schema in carte bancaire, which, as the Court of Appeal emphasised in Ping, is fully applicable to vertical agreements too. That brings me to my fourth and final topic, which is the distinction between a hardcore restriction under the block exemption and the concept of an object infringement. I said at the start that the CMA has not sought permission to intervene on ground 3, but this topic is relevant, at least potentially, to ground 2, about which we've made some submissions in writing. Ground 2 essentially concerns the tribunal's application of the law to the facts, and you have our points in writing that the CAT's error of principle in paragraph 46 of the judgment does appear to have carried through into its description of the task that it was undertaking when it analysed the evidence, but I say nothing about the actual analysis of the evidence that the CAT undertook and leave that to the parties. The only point I propose to develop orally under ground 2, as I say, is the debate about whether an agreement that constitutes a hardcore restriction under the block exemption may be assumed to restrict competition by object for the purposes of Chapter I Prohibition. And the relevance of that point to ground 2 is that the CAT referred to the fact that the agreements, as it characterised them, constituted hardcore restrictions under the EU block exemption as part of its analysis of whether the agreements restricted competition by object.
It cites Superblock.
Yes, indeed.
This, and
it did.
I thought Superblock said precisely the opposite.
Well, that's one point, indeed. The CMA did not, in fact, read the CAT's judgment as saying that a hardcore restriction under the block exemption is necessarily a restriction of competition by object, but we leave the question of the interpretation of the CAT's judgment on that point to your lordships. The CMA's, the point that the CMA wished to emphasise, and emphasise in its written submission at paragraph 18, is simply that there is no necessary overlap between the concept of a restriction of competition by object and the concept of a hardcore restriction. So insofar as the CAT suggested otherwise, it would have been wrong to do so. My lord, you mentioned Superblock. We had not anticipated this point to be controversial, given in particular also what is said in Ping in the Court of Appeal at paragraph 29, which is Authorities tab 11, page 385. Mr. Dimitri showed you this morning. The Court of Appeal said that the two concepts are, quote, not the same. The respondent nevertheless says that the CMA's position on this point is surprising, and that's Core 9, page 120, from its response to our written intervention, but it doesn't actually seek to challenge, unsurprisingly, the basic proposition from Ping.
So which paragraph of Ping was it?
Paragraph 29, Ping, Authorities 11, page 385.
Oh, yeah. Yep.
And just briefly, the respondent suggests that there is some inconsistency between the CMA's position on this issue as reflected in its written intervention and some published CMA guidance. It says that at paragraph 9.c of its response to our intervention. I don't need to turn these documents up, but the respondent first refers to the vertical guidance at paragraph 8.4. That's Authorities 6, tab 36, page 2229. But when one looks at that, all that in fact says is that hardcore restrictions, which may include RPM, are generally restrictions of competition by object. And that's fully consistent, we say, with the proposition that there's no necessary overlap between the two concepts. Finally, the respondent also cites the CMA's October 2021 recommendation, which Mr. Michu took you to after lunch, which is at Joint Authorities 5, tab 35. That was the document by which the CMA recommended that the EU block exemption regulation...
in fact, your point about the guidance is made explicit in the next paragraph, 8.5, isn't it?
It may well be.
Exactly. You just commented on the first bit of 8.4.
Quite right. No, you're right. I meant to show you that.
But 8.5 goes
the point
on.
my learned friend relies on, as well as not being inconsistent in its own right. The next paragraph shows you the CMA's position very clearly, yes. And then in the second document, CMA document that's said to be inconsistent with this point is the recommendation, which preceded the introduction of the UK vertical agreements block exemption order. Learned friend relies on paragraph 5.11. That's at Joint Authorities 5, tab 35, page 2131. We could look at that very briefly. Page 2131. And just for context, the context here is that some of the respondents to the CMA's consultation on the block exemption had argued that resale price maintenance should not remain a hardcore restriction under the UK version of the block exemption, and the CMA, having considered those matters carefully, decided to reject that suggestion. And paragraph 5.11 does say that retaining RPM as a hardcore restriction under the UK order is consistent with the well-established principle that RPM amounts to a restriction of competition by object. We say it reads far too much into that sentence to say that CMA therefore takes the view that RPM will always amount to a restriction of competition by object. And in any event, text is not intended to and cannot vary the law on object infringements as stated in cases like carte bancaire, bids, and the other cases that your lordships have seen. I don't want to overstate the position. CMA is not seeking to suggest that there will be many real-world cases where RPM would not be found to constitute an infringement by object. The CMA's focus is simply on ensuring that the test for an object infringement is not misstated, given its significance to the CMA's work more generally. And in conclusion, and having used rather less than my hour, given the need to avoid duplication, while the CMA has no dog in this fight in terms of the outcome of the case, it does regrettably consider that the judgment involves an error of principle as to the nature of the overall test, and it invites the Court of Appeal respectfully to clarify the proper legal position in its judgment. Unless I can assist further, those are the submissions of the CMA.
Thank you very much indeed. Mr. Khan.
Thank you, my lord. I think I can get started and at least deal with a number of preliminary matters before turning to the meat of the matter tomorrow. As the court will be aware, this is one of these unusual appeals where permission to appeal was given not on the basis of Decker's having a real prospect of success in setting aside the CAT's judgment, but for wider reasons. Up and Running understands that the appeal is an opportunity to examine some of the difficulties that arise in applying Chapter I to selective distribution, and I will try to assist the court on those wider issues. But before exploring those, I would like to emphasise that Up and Running advanced a very simple and straightforward case before the CAT that relies on well-established principles about the application of Chapter I to selective distribution systems in the very specific context of the case. Even defending that limited case on appeal would have been impossible without the continuation of cost protection for Up and Running, and so I should say at the outset that Up and Running is most grateful to the court for maintaining its cost protection. Now, despite the simplicity of Up and Running's case, the appeal, you see this in paragraph 5 of the skeleton from Decker's, tries to dismiss preemptively Up and Running's case by claiming that if the judgment stands, it'll be a catalyst for unwarranted litigation. My lords, it will be quite the reverse, in fact. If the judgment is set aside and judgment is issued in favour of Decker's on the basis of its essentially content-free appeal to the claimed coherence or integrity of its selective distribution system, then selective distribution systems will be granted an almost blank cheque by competition law. We will go to the cases in due course, but just to flag right now, Lady Justice Rose, as she then was, noted in Ping that competition rules have indeed respected a manufacturer's choices as to how best to promote its product, but only to some extent. But a judgment on the basis sought by Decker's will send a signal that those bounds, the extent to which the competition rules have respected or liberated manufacturers' choices in this respect, will have been greatly extended, resulting, coming back to the predicament faced by Up and Running here, of there being very little realistic possibility of Chapter I being enforced in relation to selective distribution systems, especially in private litigation where one is liable to have, as we have here, David and Goliath litigation. in addressing the court today, my learned friend Mr. Mitri was regretting that before the CAT there was an absence of sophisticated economic analysis. It's just not realistic for a member of a selective distribution system like Up and Running to embark on that sort of sophisticated litigation. And that's why I say that if a judgment is granted in the terms sought by Deckers, then private enforcement in relation to selective distribution will be all but impossible. Now, this is particularly important because, as recognised in my Lord Justice Green's judgment granting permission to appeal, selective distribution systems are a ubiquitous feature of the retail economy, which means they have obvious widespread effects on consumers in terms of pricing and availability of goods. So there's a strong public interest in the enforcement of Chapter I in relation to selective distribution systems. Now, in private actions such as this, well, quite inevitably, they are going to concern one isolated situation, and yet that's being invoked by Deckers as a reason to grant the appeal. Their argument is effectively that, well, this is only about one incident, one distributor of Hoka shoes. It's just a niche problem. But my Lord's describing it as a niche problem. Now, that really is competition law by numbers. But in fact, it isn't even really competition law because, as I will demonstrate, that proposition that it doesn't matter because we're only talking about one incident in relation to one retailer in one selective distribution system is simply wrong as a matter of law. Since selective distribution is the area of competition law that's most likely to engage small companies, like Up and Running, for enforcement to be feasible, the rules have got to be sufficiently clear and workable, and yet the appeal invites layers of complexity that are inimical to that. Now, turning to the case before you, one of the ironies of it is that we're all agreed, I think, that selective distribution rules accept that there is some inherent weakening of competition, even price competition, in selective distribution systems, and that's justifiable to ensure the existence of retailers offering higher levels of service, and Up and Running was exactly such a retailer. The witness statement of Mr. McFarlane, that's in the supplementary bundle, tab 19, but we needn't go there now. He is the founder and driving force behind Up and Running and explains that Up and Running had become Decker's third largest Hoka reseller in the country. And so it was, of course, a cause of dismay to him that Deckers withdrew supplies. And yet, even after the commencement of the litigation, you see that on the one side, Mr. McFarlane retained great admiration for the technical qualities of Hoka running shoes, and on the other side, at trial, Mr. Hager admitted that he had no quality concerns about the running shoes website. And yet, we end up where we are after an unhappy course of events, which has its origins in Up and Running's predicament following the COVID-related restrictions, as Mr. McFarlane explains. Now, I'm sure your lordships will recall that those initial blanket restrictions were introduced in March 2020 with the comforting assurance from the Prime Minister of the day that we needed just 3 weeks to squash the sombrero. Well, in the event, restrictions endured, and that meant that by summer 2020, Up and Running found itself with an unsquashable bulge of unsold stock, and it had no liquidity to pay impending invoices from suppliers for new season stock that was coming, such as Hoka's, of around £1 million. And so by June 2020, Up and Running was almost down and out, and it absolutely had to offer clearance discounts in order for its retail outlets to survive and thereby continue to provide high levels of service that selective distribution systems are supposed to encourage.
Can I just pause you? Something you said about a minute ago about it may just be in passing about the commentary that Decker's had about the website.
Yeah.
You said there was no criticism of the website.
In terms of its quality.
Which website?
I'm sorry, my lord. Yes, the Running Shoes website. That's the second website that that Up and Running set up to dispose
Right, so
on a
it-
clearance basis.
The so-called anonymised one.
Yes,
the
anonymised one.
non-branded,
So-
if you like.
So they so that somewhere in the evidence, or somewhere in the findings,
Yes.
or whatever, there's a sort of it still looked okay. It still
Yes.
was a quality.
Yes, we will come to that.
Website.
Well, to anticipate the event slightly, the refusal of Decker's to allow the Running Shoes website, which of course vis-a-vis Decker's was by no means anonymous, they knew about it. Their refusal wasn't based on any quality considerations. It was very tersely stated, but it didn't have anything to do with quality considerations, and that indeed came out in the evidence at trial. So we have a situation where we're on appeal, with an appeal that accepts the judgment's findings that Decker's distribution system failed to meet the Metro requirements, but the practical reality of the appeal is that it seeks to greatly expand an exclusion from Chapter I for a selective distribution system that, on its own admission now, doesn't meet the standards prescribed by Metro, has no particular rhyme or reason for its terms, and even accepting, as the judgment does, that the distribution system is in place for a type of product that can satisfy the logic underlying the Metro exception from Chapter I, the essential thrust of the appeal is to seek to rely on some kind of enlarged Metro exception, even if not by name. And that is very difficult to reconcile with what we should be dealing with, which is the judgment under appeal, which is based on Up and Running's claim, which related to very specific restrictions, which at trial Decker's sought to counter by its signposting defence. And Decker's, it seems, has belatedly realised that signposting is a road to nowhere. So the essence of the appeal is to fall back on this even more nebulous notion of consistency with its selective distribution system. You see this, for example, in paragraph 62 of the Decker's skeleton. That simply doesn't engage with what the judgment was asked to address. The judgment is an analysis of whether Up and Running had made out the two restrictions it complained of. The basic flaw of the appeal is to characterise the judgment, whose concluding section is at pains to point out that it turns on very specific features, as making some sort of general challenge to any restriction on intra-brand competition. Decker's claiming, in effect, that as its trite law that distribution systems inherently reduce intra-brand competition, then its own distribution system can't possibly present a sufficient degree of harm to competition. Well, my lords, an appeal to this unidentified abstraction of preventing inconsistency with Decker's selective distribution system doesn't answer the judgment, which finds that Decker's selective distribution system was consistent with and did in fact apply two specific infringements by objects, which are summarised in the judgment, paragraphs 214 and 216. Now, as the judgment explains, the infringements found on the facts correspond to established categories of by-object infringement, and no relevant aspect of legal or economic context undermines that conclusion, which is reinforced by the practices being hardcore restrictions under the vertical dock exemption regulation, in relation to which the domestic, ECJ and authorities and the Competition and Markets Authority are all agreed strongly points towards classification as restrictions by object. So, our lords, if despite the appeal not seeking to maintain the signposting justification, which was absolutely the central plank of Decker's case before the cat's judgment could nevertheless be set aside by recourse now on appeal to notions of coherence or consistency, then private enforcement of Chapter 1 would become all but impossible. So with those introductory remarks, I can turn to ground 1. So ground 1 asserts that the judgment erred in applying a presumption that any provision, at least in the selective distribution system, is an infringement by object unless it can be shown to pursue and be proportionate to a legitimate aim. In our submission, the judgment applied no such presumption or reversal of the burden of proof, and the CMA agrees with us about that. We have already been over that, so I won't elaborate greatly on it, but Up and Running's position is confirmed by the fact that so much of Section H of the judgment is devoted to going through the carte bancaire requirements. The appeal is misdirected in our submission in focusing on this early part of the judgment around paragraphs 42 to 46, because those are only introductory remarks in the judgment. But even if you attribute some significance to that first part as informing the CAT's conclusions, the CAT made no error there. If one looks at Decker's skeleton, which is at tab 5 of the core bundle, paragraph 40, which is at page 53 of the bundle, there it's admitted that the judgment began by reciting the key uncontroversial propositions about the relevant law here, but then argues over the page 54, paragraph 41 of the skeleton, it argues that the judgment suggests that the approach had been fundamentally transformed by the Court of Justice's judgment in generics, referring there to paragraph 46 of the judgment. My lords, it's extremely unlikely that any such approach was taken by the tribunal, when one bears in mind the context, even going no further than this first part of the judgment. Because if you look at the judgment in core bundle tab 10, paragraph 42.1, it's at page 145 in the bundle, then under the heading, the correct approach to a by-object assessment, then the very first thing that is mentioned, this is in paragraph 42.1, as the key question, is to determine whether the contractual provision presents a sufficient degree of harm for competition. In determining this question, it is necessary to consider the content of the relevant provision, the objective aim it pursues, and the legal and economic context of which it is a part. So the key question is a sufficient degree of harm, and it refers to carte bancaire, all of which ought to cause no concern on the part of Decker's that there is any error here. So that's the very first thing the judgment reminds itself of. And then in paragraph 42.7, over the page 147 in the bundle, we have the reference to Super Bock, where the court reminds us that resale price maintenance is understood to be restrictive by object in many, if not in almost all circumstances, which really ought to be a completely uncontroversial proposition, and it refers to the Court of Justice's judgment in Super Bock. But it reminds us always that one has to verify that the restriction presents a sufficient degree of harm, having regard to its context. Now, in paragraph 46 of the judgment, which is the focus of Decker's attack, the judgment does paraphrase generics as if it's asking if the provision does not plausibly pursue a legitimate aim. But one has to bear in mind that paragraph 43 begins turning to the assessment of the objectives of the contractual provision. And then even before that, the judgment has noted the presumption in relation to resale price maintenance in vertical restraints. That ought to make it clear that the CAT is turning its attention here to the objectives of the provision, and that's consistent with generics because the focus there really was on identifying what the real objective of the parties was to determine the issue, and the legitimate aim question is being used as a shorthand for asking if the parties to an agreement were pursuing something to be characterised as a restriction sufficiently harmful to competition to be a restriction by object.
So you're basically saying that 46 doesn't undermine, taken in its context of the run that starts at 43, it doesn't undermine 42.1 or 42.7.
Indeed, my lord. I mean, one can criticise, of course, the formulation of some of the phrases used in the judgments, but in terms of what the judgment is doing, it is, I submit, perfectly orthodox and consistent with what generics was doing. It may be perhaps useful to turn to generics if there is time still today.
Yes, I mean, if you want 5 minutes on generics, or if it will help you, or you can save it tomorrow. It's up to you.
I think, my lord, as I've just mentioned, generics,
Yeah.
we probably could go.
Can I just ask you about the analysis and the judgment you've taken us through?
Yes.
So from paragraph 43 onwards, the CAT is extolling the importance of generics upon the basis that it was delivered after Ping and binding upon it.
Mm-hmm.
And so it refers to the facts. It refers in 44 to the question addressed by the court, which was what was meant by an object restriction. It identifies the central question in paragraph 45, which is how the referring court should go about deciding whether objective could be said to be other than agreement to engage in competition on the merits. Then cites 87 to 89, says that that's binding upon us, and then it comes out in 48 with its conclusion. Now, 87 to 89 of generics are in the part of the judgment in which the court is considering object and the defendant's submission, a bit like existence exercise in IP cases, that there couldn't be an object restriction because it was all commensurate with the scope of the patents. But there are these paragraphs before that which say, well, object's just one of the ingredients. You've also got to look at economic effect. But they don't refer to those paragraphs here. They go through the analysis of the judgment on object, and then in 48 seem to think it's the test.
My lord, yes, they only cite a few paragraphs from generics here, but as my Lord Justice Snowden mentioned, this is just one part of a section of the judgment that begins, perhaps one could say it begins even at paragraph 37 on Metro, but then it moves on from Metro to the next stage of the analysis, paragraph 42, where it, on anybody's view, very correctly states the task ahead of it in paragraph 42.1.
Yes.
But to pick up on your Lordship's specific question about generics, I should then, I think, turn to generics, so that...
I mean, if you'd rather take your time and do it tomorrow, I mean, you're very welcome to me. I think it will require a little bit of unpacking. Maybe it's you want to have a think about it overnight. And
yes, I'm in your Lordship's hand, but I'm very content to leave it till tomorrow. If you think that would be better, yes.
I don't think you'll be better or worse, but I think it'll give you a chance to think about the judgment, because I think, given the importance which the CAT attached to it, I think it would help us to go through it a little bit more systematically to see how these paragraphs, 87 and onwards, of generics fit into the court's overall assessment of the test it thought it was applying.
Indeed, well, I would emphasise before we adjourn that the section of the judgment where the tribunal was actually applying the law to the findings comes very much later on in
It
the
does
judgment.
indeed.
These are only warming up
Yep.
preliminary remarks, which one should not attach too much emphasis to.
Okay, thank you very much indeed. So,
Thank you.
10:30 tomorrow morning.
All right, table.